Um, you can probably just tell by the density of the material that this is one of those subjects that's more important than future interests in rap. This is possibly something that could play a lot heavier on your exam, depending on the type of question he wants to write. If I remember correctly, what was it last year, on the final there was a question for landlord tenant, so it's a possibility that it could be on the exam. Um, the idea that you need to start off with, with regards to landlord tenant, is you have to kind of think about it in two parts. The first part is, how do we form a landlord tenant relationship, and then the second part is, what are the rights and obligations of each party. That is essentially how you can break down landlord tenant. But you know, easy enough to start. You have formation. These are just basic definitions for the landlord, obviously, and the tenant. Um, this is one of those areas of property law where property law weighs heavily with contract law, but also has its own kind of spin to it. Um, so if you have a kind of an understanding of basic contract law, which I know all of you do because you have been paying attention in your contracts classes, this is going to be kind of similar, and uh, just maybe a couple different nuances um, than you're used to. But we'll start off with essentially, what is a lease? So a lease is a device that the landlord grants a right of exclusive possession of a specific real property to a tenant for a specific term, with a reversion in the landlord at the end of the term. Um, this definition is accurate, but it also makes it kind of sounds like it might be like some sort of real conveyance. The It is a term of years or a period term conveyance in a way, but there's like a very, very strong reversion in the landlord. Um, Whereas if it's like a conveyance for a term of years, um, just essentially, you don't want to think about this as like a future interest type issue. You just kind of want to focus on the fact that this is like what you signed for your apartment. Don't try to connect this too much to future interest law. Despite my notes, the future interest aspect of it doesn't play as heavily into it. So don't try and connect it too heavily to future interest. But when we were talking about a lease, if you guys want to know the breakdown of the interest stuff that's involved, there's a present possessory interest in the estate in the tenant. The future interest is in the landlord. And the bare bones elements of a lease is a description of the property to be leased. And this is important. This is no longer a part of like the interests and stuff like that. This is pretty important to know. So the elements of a lease is a description of the property to be leased, the amount of rent to be paid, and then the period. Um, so it's got to have essentially these three, regardless of the form of the lease. Like, these are almost always necessary in a lease. Otherwise, it's like you don't know what property you're purchasing. You don't know how much you're paying for it. You don't know for how long you're able to lease it. So each of these elements is extremely important to a lease, and these should appear in every lease that you encounter. Um, in the most strict sense, the lease form, they're considered conveyances because the exclusive right to possession is essentially no different than any other estate. Again, this isn't as important when we're talking about testable material because the focus is going to be on rights and obligations. This is just something I'm letting you know with regards to formation. But again, formation is less a subject that you're going to encounter on the exam, and it's going to be more about rights and obligations once we get down to that section. Some leases have contractual elements to them. Thus, there is a trend in the law to move away from interpreting leases under property law and starting to use contract law. This is what I mentioned earlier. You're going to see some stuff that you've probably encountered in your contract law class. But one of the things that's kind of important to remember is that there is still the element of this is property law. And so there are courts that take a different spin to leases than a normal contract law court might. An interpretation through contract law changes the obligations of the landlord. So this is just something to be aware of, is that contract law does apply. This doesn't mean that you have to like take double notes in your contracts classes. This is just something that contract law in this instance could apply. But that doesn't mean on the test that you're going to have to be like, referencing like Lucy v. Zemmer for some reason. When viewing a lease as a conveyance, all other covenants within the lease are independent from the lease. If a landlord breaches a covenant, the tenant must still pay rent. So what this is saying is, if you have a multi-tiered lease that has other contractual elements in it, so for instance, you have a lease with maybe some other contract within it, the lease, oddly enough, is going to be viewed as almost like a separate contract within that contract. Even if there's a separate covenant breached, the lease is still good, essentially. So the tenant must still pay rent. So this would be something like a property is leased via rent, and then the landlord has an obligation to, say, provide upkeep for the property. So that's kind of a separate covenant within the contract. And so even if the landlord doesn't provide upkeep for the property, that doesn't mean that the tenant doesn't have to suddenly pay rent or that the whole thing is bust. You'd still require the tenant to pay rent. In that instance, you would just have a situation where if it ever ended up in court, which that would be wild, you'd end up having the court ordering the landlord to fix the property, essentially, and essentially they'd order the landlord to do their job or perform under their covenant, or they'd ask for, or they'd tell the tenant that, or they'd tell the landlord to pay damages to the tenant. But that would be an instance where you just need to realize that the obligation, and this is starting to bleed into the obligations and rights section, the tenant still, almost in every circumstance, has an obligation to pay their rent, regardless of what the landlord does. Only in the most extreme circumstances are we not going to require the tenant to end up paying their rent. Okay, moving down to contract law versus property law. This is common property law. So the landlord has no duty to mitigate damages if the tenant walked away. Sorry, as an aside, this is not applicable in all jurisdictions. There are some jurisdictions have essentially written laws out of this. So this isn't always true, and you need to be aware of what jurisdiction you're in. But the common law is that a landlord has no duty to mitigate damages if the tenant walks away from the property or walks away from the lease. The tenant would still be on the hook for rent. We'll get to another part of this where that's totally different. So this is an instance where the tenant breaks the lease and leaves, and stops paying rent. In some jurisdictions, this would apply where the landlord doesn't have to, say, look for new property, or look for a new tenant for their property. They would just be able to run up the charges against the tenant, essentially. So they could actively not have somebody come and take over the property as a new tenant. And instead, they could just sit there with that apartment empty and just run up charges of late rent against the tenant. On the flip side, we'll come into contact with this later. There is, and this is in the contract law section, I'll get to this. There is a duty for the landlord to attempt to mitigate damages when the tenant walks away. So if they're not actively trying to fill the space, they're not going to be able to collect against the tenant. Second part of this is the landlord didn't have to make repairs to the property. If the tenant had exclusive right to possession, we asked the question, why would the landlord enter the land to fix it? This is just one of those old common law things where, because we've granted exclusive possession to the tenant, courts used to not be very cool with forcing the landlord to fix the issues. There was actually this weird, and this is probably odd for some of you who have leases. You're probably like, wait, I've always had to like approach my landlord before I'm even allowed to touch anything in the apartment or in the home that I stay in. That's because this isn't really no longer applicable. Usually what the law is that the landlord does have to fix property essentially. But the old way that it was done was the tenant was actually on the hook for fixing property. Um, which oddly enough wasn't good for the landlord because then they don't get to have sort of control over how their property is fixed. So that's why this isn't really applicable, just because it's not really good for anybody involved. Um, there are some jurisdictions where the mitigation of damages is still the same, but as a general rule, for all of common property law, with regard to leases, we have moved more towards the contract law way of doing things. I kind of think this is the modern way of doing this. So an example of contract law over common property law, whoops, misspelled something again. In the event of tenant abandonment, the landlord has to mitigate damages by finding a replacement tenant. So this is what I talked about earlier. And this is probably the more modern way of doing things. Okay. Get rid of that. Okay. Statute of frauds in leases. So some jurisdictions require leases that are greater than 1 year to be subject to a statute of frauds. Other jurisdictions require 3 years. This is just something to keep in mind. Don't get into the weeds on it. You may just want to keep an eye out for it. I can't see how this would end up being important on the exam. Other than, yeah, I would even hazard to say like maybe bring it up to get like bonus points if you want to like kind of maybe impress Bogart a little bit, but he sometimes kind of wants you to stay on point. So I guess this is just something to be aware of, is that statute of frauds does apply for leases longer than a year, and in some jurisdictions longer than 3 years. In the event that statute of fraud applies, you look for the 3 Ps. So property, so there's a specific lease premises, the price, so this would be the amount for the rent, and the identity of the landlord and the tenant. Again, in a statute of fraud situation, which is again something I did not encounter on the exam, if I remember correctly, these are the 3 things that need to be present within the written instrument. Then you also need to be aware of, plus statute of frauds requires signed writing for lease periods over 1 year, different but similar to a lease is a license. We'll go ahead and talk about that in a second. Sort of test advice on this one. It's one of those things where it could be tested, so I don't want you to tell you to ignore it, but I also don't see him developing an entire problem on statute of frauds for your property law final. Be aware of it, be ready to write something on it, but I wouldn't spend a ton of time on statute of frauds with regards to property law. Just be aware of it's 1 year to 3 years is usually the jurisdictional requirement. Look for the 3 Ps, which is just what is the property, what is the amount paid, and then who are the identities of the landlord and the tenant? Are those in the written instrument? Yes or no? Is it signed for the, and then move on. I don't see a situation where you'd actually have to do a statute of frauds analysis. But again, be aware of it. So a license is, and we're going to contrast this with a lease in a second. So this is a personal right based in contract where the licensor gives the license a narrow right to use real property for a specific reason. This is not a lease, and it doesn't need to meet the same lease requirements. This is something where you would actually say, in this instance, if I'm not mistaken, you would actually say that the present possessory right is still in the landlord. There's just been a specific right given to some sort of other individual or party to use the property in a specific way. I'm trying to think of an example for this. I think this would be something like you have a contractor coming onto the property to build something. You've given them a license to use the property by building it. Or let's say you own a field and you have, this is so specific and kind of Field of Dreams ish, but let's say you have like a baseball field on like your farm and you give a license to like a local little league so that they can play baseball on the property. They're not a tenant of the property. You've just given them a license to use your personal property for a specific reason. We would still say that you have present possessory right over the property. The personal right is based on contract law and is totally revocable by the licensor. You can revoke your license to somebody to use your property at any time. Yeah, that's essentially it. The lease versus a license. So the most important point to keep in mind as you analyze the possible factors is that more dominion and control the owner has over the premises and the user's behavior while on the premises, the more likely that it's going to be a license. Oral leases are permissible provided they do not exceed the period specified on the statute of frauds, which in most states is 1 year. So that's just to give you sort of a contrast of most licenses are going to be oral, just based on the nature of how we kind of go about doing a license to use a property. You'd usually just say to somebody, yeah, you can use the property for that reason, and you've given them license. There are some cases where you can do a lease, but an oral lease, if it doesn't have to meet the statute of frauds. And that is pretty much with regards to statute of frauds. It's just really determining whether it's a lease or a license. Because you can give a license orally for as long as you want, but you can't do that with a lease. The other thing to keep in mind is if the owner retains significant control over the property and the user's behavior on that property, the more likely it's going to be a license. So just keep all of that in mind. Once a lease is identified by the court, then the parties of that relationship are now subject to the duties under landlord-tenant. Again, this is something we will get to further down. But just keep in mind, a license does not create the obligations and rights that a lease would. So there are 3 categories of leases. There's a term of year tenancy. The leasehold terminates on a certain date. It must contain a fixed date of termination. This actually isn't correct. I went back and looked at this. In most jurisdictions, there is, in fact, in all jurisdictions, there's a limit on how long you can lease for. But a landlord could theoretically lease for 1,000 years. This is more like 99 years. However, some jurisdictions put a limit on the length of the lease because they start to look like a transfer of fee. This isn't totally correct. Again, the most places have a lease term of 99-year max, and then because they have that statute laid out lease term, they don't look at any lease as a transfer of fee unless you do one of those what we talked about where it was a hidden mortgage, where we have a lease that is actually a mortgage. Go back up to your section on transfer for that, or on conveyance for that one. There's also periodic tenancy. The leasehold continues for a successive period of equal time. So it's a month to month unless one party notifies the other of its intent to terminate. So this is that you have each of your, instead of saying like, oh, we've got a time where it definitely ends, excuse me, we just say that the lease will continue every single month unless one of the parties tells the other it's over. The lease does not end in the middle of a period. So if you're doing a month by month lease, nobody can terminate in the middle of the lease. There are 2 main questions that are asked with regards to a periodic tenancy, and how is that tenancy created, and how is the tenancy terminated? So it is always created by express language, which would be something like year to year, month to month, every 2 months, you pay a certain amount of money. It's pretty explicit in how we create a periodic tenancy, and then how it is terminated. So either the landlord or the tenant gives notice. The notice is usually qualified within the lease. So it'll say like how, to whom, the method of delivery, like mail, electronic, etc. So basically what you're looking for is how is it terminated, to whom do you need to give notice, and then the method of that notice. The kind of the big question is how much notice do you have to give? Under common law, the amount of notice needed is the length of the period. So it would be, you need to let them know one full, like if it's a month to month lease, you would need to let them know the prior month before they got kicked out. Or before you would end. So if you're the landlord, you have to give them a full month's notice, a full term of the period. Today, jurisdictions have enacted statutes reducing the number of days needed to provide notice. So in some jurisdictions, it would be 10 days for a week to week, or 30 days for a month to month, or longer. And that's essentially it. It's usually statute based. So on the exam, if you're dealing with a question that deals with the termination of a periodic lease, most likely you're going to get a separate statute that gives you the amount of time that a landlord or tenant has to give notice. The final type of lease is a tenancy at will. The leasehold does not have a fixed period and lasts until one party informs the other that the lease is terminated. Both parties have the ability to walk away from the lease at any time, and some of you are immediately going, that's really, really dumb. And so there are very few of these today. Not a lot of landlords like to do a tenancy at will. Landlord essentially says that they will lease for as long as they want to, and for as long as they wish to have the tenant, essentially. The termination right is reciprocal. If one party has the right to walk away, then both parties have the right to walk away, even if it's not specified in the lease. So basically, anybody, if one party reserves the right to walk away from the lease, which, yeah, that's always going to be the case, then both parties always have that right to walk away from the lease. In the absence of the term defining language, so in absence of how long the lease would be, the landlord, so when the landlord and tenant forget to specifically state the type of lease, the default is a tenancy at will. This is what I was saying, was these are usually really dumb to try to put yourself into. Most of these are created by accident. This would be a situation where all the other parts of a lease are present, except for the term, and so you have just accidentally created a tenancy at will. These are normally created by just really dumb landlords who forget to tell their tenants how long they have to stay, and so they kind of get themselves backed into a corner. Usually, you might, if you're on the exam, you might get one of these created intentionally, but just as like a practical note, this is one of those things where it would be very silly to encounter one of these in real life that wasn't created by accident. Today, many jurisdictions have stated that there's a minimum requirement of notice before somebody gets kicked out. Because of just how kind of squishy tenancy at will is, a lot of jurisdictions have had to step in to kind of come up with, time frames that are necessary for these different, for like the landlords to kick out a tenant, or for the tenants to break their lease, stuff like that. So the length of the minimum requirement of notice varies from jurisdiction to jurisdiction. excuse me, this minimum requirement of notice turns most tenancy at will into periodic tenancy. So this essentially states have stepped in to, provide dumb dumb leases with some sort of semblance of sanity. So in a lot of jurisdictions, if you kind of, for a lack of a better term, stupid your way into a tenancy at will, the states fix it for you and turn it into a periodic tenancy instead. So just be aware of that. It may be impossible to create a tenancy at will depending on your jurisdiction, which is a good thing. Okay, so now we're starting to get a little bit into the rights of each party. So a tenancy at sufferance and holdover tenancy. See, ton of problems here. Tenancy at sufferance. So this is when a tenant remains on the premises after their term has expired. When a tenant who is a tenant in one of the three tenancies holds over, and they're wrongly holding over in the property after the termination of that tenancy. So this is essentially when the landlord has done everything that they need to do under the lease to terminate the lease, and the tenant will not leave. And we'll kind of talk about a little bit more about why the tenant or why the landlord can't just like kick in the front door and literally throw somebody out. This can be a real problem for landlords where somebody holds over and doesn't stay. And there are certain ways that we go about handling this. When a tenant wrongfully holds over, the tenant is inviting the landlord to keep the tenant in a leasehold relationship. So what's kind of interesting about a tenancy at suffrage and a holdover is that the landlord is given an election. So this election is that you can treat the tenant one of two ways. You can treat them as a trespasser, which then causes the landlord to essentially be allowed to do anything that you would normally do if you had a trespasser. When the landlord treats the holdover tenant as a trespasser, there's no notice that's required in anything that follows. The landlord can simply begin basically the proceedings that would cause you to kick out a trespasser. So you can go to court, do everything that you need to do. Once you're given the right, you can begin sort of moving on that. You can bring the sheriff in on it. Adverse possession only begins when the tenant is informed they are trespassing. So this is something that's super important to keep in mind, because this is one of those things with regard to landlord is a landlord tenant problem can very quickly wombo combo into a adverse possession problem. Be super, super aware of this. That's why I put it in bold. I should probably italicize and underline this. This is super important to keep in mind. If you come across a landlord tenant problem, there is a very real possibility that this turns into an adverse possession problem, and it does so very quickly. So I can't say enough how much you need to be aware of this. The second option is that the landlord can treat the tenant or the holdover as a tenant under a new lease. When the landlord treats the holdover tenant as a tenant under a new lease, most jurisdictions would say that the old lease terms govern. There are some jurisdictions that say there is a new lease, that the new lease is periodic rather than in a term of years if it was a term of years before. The period can never be longer than a year. So this is just saying that most jurisdictions just say like, it's like renewing the old lease all over again. There are some jurisdictions that say that there's sort of like a strict way that you handle this, and it's a periodic and it never goes longer than a year. So just be aware of that. With regards to adverse possession, if a landlord selects this option, adverse possession issues don't apply because it's no longer an adverse possession. It doesn't meet the terms of an adverse because the landlord is welcoming essentially the tenant under a term of lease. Prior to the landlord's election, The tenant is considered a tenancy at sufferance. Excuse me. The tenant is therefore obligated to pay the fair market value of the rental when the tenancy is by sufferance. I'm not going to try on that one right now. There we go. So what this means is that until the landlord makes an election, we consider that the tenant at sufferance, I guess is what we can call them, the holdover tenant or the tenant at sufferance. Instead of paying whatever the lease was sort of laid out, we just judge it on the fair market value until an election is made. And there's usually, that's another thing I didn't mention, is there's usually like a time frame that the landlord actually, no, there's not usually a time frame. I think you can have a situation where the landlord doesn't make an election for a long period of time, and this market value sort of tenancy is required. But there is going to be a point where the courts start going, we're going to make the decision for you. And that's less case law based and more just like courts getting really annoyed with landlords, is they will kind of just make the call for them. And we're talking very long periods of time. And this is also not an issue that you need to worry about on your exam, because it's going to be laid out pretty clearly what goes on. Managing the relationship. Now we are fully into the rights and obligations of the landlord and tenant. Before I get to that point, does anybody have any questions before I get into rights and obligations? Okay, I'm gonna go ahead and keep moving on. I'm gonna try to only go probably another, say about 10 minutes. We'll start into this and then we will move on. Oh, again, we were getting tired at the end of this point, so we were just dropping in memes left and right. So managing the relationship. When we get a landlord tenant, we need to focus on the obligations. We need to focus on which obligations are implied and unable to be contracted away, and which obligations are those that can be contracted away. What this means is that there are some obligations and rights that always stick or are implied in a contract. And there are others, rights and obligations that we can get rid of in a contract when we form a lease. And so we need to be aware of those when we do form a lease. So this is landlord duties and the consequences of failures. So the right of possession. At common law, the only obligation the landlord was to place the tenant into possession of the property. So essentially, they only needed to deliver the right of exclusive possession. Again, this is very basic common law, and this like never applies anymore. Almost. There are some jurisdictions that kind of use this as a basis, but more often you have a split between the American versus the English rule. So the American rule is essentially that there's an exclusive right to be delivered. The tenant's job is to evict anybody else on the property. There are some instances in a commercial lease that the American rule is more efficient. So the American rule is essentially that once the landlord has provided the property to the tenant, it's the tenant's job to evict anybody else that comes onto the property. Now contrast that with the English rule, is that the landlord must place the tenant in actual physical possession. So essentially the American rule is that all you have to do is convey the property insofar as they have the right to exclusively possess the property. You don't actually, under the American rule, have to give somebody the property. You don't have to make it so, essentially. You just have to give them the contractual right to the property. The English rule, on the other hand, says that the landlord must actually place the tenant in physical possession of the property. This means that there is an obligation under the English rule for the landlord to eject squatters essentially on the property, and that the tenant has a right to cause the landlord to have to enforce essentially the right that they have over the property. This is followed by I don't know why. Oh, a weak majority of the states. So what I meant by that is it's barely a majority of the states follow this. The restatements and URLTA both adopt English rule, and some say that in the residential sense, this is more efficient. So essentially, in commercial leases, the American rule is more efficient because we're dealing with probably, property holders or property companies like the Irvine Company, who are managing like hundreds, probably thousands of different pieces of property, where they can't always be ejecting squatters from the property. And so it's easier to have the tenants do so. In the residential sense, the English rule is more efficient because the landlord we look at the landlord as being somebody who's more capable and has more resources to eject a squatter than the tenant might be. And so that's just something to be aware of. But yeah, so the English rule is essentially you just need to give the contractual right to the tenant, whereas the English rule is that the landlord must actually provide physical possession of the property to the tenant by ejecting squatters, essentially. Yeah, I think we can get through one more section. You know what? No, I want to do quiet enjoyment and minimum levels of habitability together. So I'm going to go ahead and I'm going to start by opening up the questions, and then I'm going to close this out. But does anybody have any questions about any of this? Any follow-up that's needed? And if you're still copying down, I'm going to leave it up for a couple more seconds. Okay, I'm going to go ahead and stay on. I'm going to go ahead and stop sharing.